Hi, welcome to Smithline Training. I'm Derek Schweed. Today we'll be talking about performance warranties and software and SaaS agreements. We'll be exploring these warranties from the vendor perspective, looking at the relevant background law, as well as best practices for your customer deals. As a quick disclaimer before we get started, Smithline Training LLC is not a law firm, and though we'll be talking about some legal issues today, we're not providing legal advice or creating an attorney-client relationship. As always, if you have particular legal questions, you should consult your lawyer. Here at Smithline Training, we follow a two-step approach. First is to watch today's episode. Second, we invite you to join us for one of our roundtables. We hold these online or in person in our offices in San Francisco, and the roundtables give you a chance to discuss questions or best practices from your own practice. As always, if you've got any feedback or questions, please contact us at help@smithlinetraining.com. So let's dive in. What's the big picture for performance warranties? What are performance warranties and why are they important? Well, performance warranties in the enterprise context are a key assurance that your customers that your product will perform properly. After all, they're paying hundreds of thousands or even millions of dollars, and they're going to want to know that they're getting their money's worth. Performance warranties are also relevant in the consumer product space, and in fact, at law, there are both notice and labeling requirements and substantive protections for consumers. As we proceed today, we'll be focused on the vendor's perspective. Meaning that a lot of the guidance we provide really will be geared toward vendors. That being said, if you normally wear the customer hat, this presentation will clue you in on how vendors often think about warranties, and we'll also be sharing some common customer requests and ways to resolve them in negotiation. So whether you're a vendor or a customer, we think you'll find some useful information in today's presentation. So what are our topics for today's presentation? We'll start with the background law for warranties. Then we'll review the best practices for your warranties and disclaimers for vendors. We'll look at the consumer warranties that I mentioned. Then we'll introduce a topic we like to call choose your own disclaimer. And this asks the vendor, beyond the standard warranty provisions and disclaimers, what additional protections should you include that are specific to your product or your key risk concerns? We'll also review the relationship between warranty and service level agreements and support. And these are overlapping, related, and sometimes confused topics. Finally, for vendors, we'll provide some tips and tricks for addressing common customer concerns. We've got two tools for today's episode, which are posted with the video. The first are a set of example performance warranties and disclaimers, which will track our best practices that we're sharing today. And the second is a downloadable tool containing the tips and tricks that we'll cover later. All right, so let's dive into the background law. One of the key sources of law for warranties will be the UCC Article 2 on the sale of goods. Now, as we're all probably familiar with from law school or the bar exam, the UCC was first published in 1952, and it's a very important source of background for warranty provisions and disclaimers. Now, you may ask, are software licenses and SaaS subscriptions really sales of goods under the UCC? Well, the answer is maybe. Courts differ on this. Some courts have held that the UCC applies to software, others have held otherwise. Nonetheless, in any event, courts are likely to rely on UCC principles, either explicitly or by analogy, and the body of case law that's grown out of the UCC. So we do consider these a very important source of background law. The second area we'll want to touch on is the consumer protection laws. We'll talk about these more in detail later, but I want to introduce them now. At the federal level, there's the Magnuson-Moss Warranty Act, which in essence is a lemon law for consumer products. Each state also has its own consumer protection laws. In California, that's the Song-Beverly Consumer Warranty Act. With that as background, let's dive into our best practices for warranties and disclaimers. And here we can take the example of a company called Service HR, who you may remember from some of our other presentations. Service HR offers a SaaS solution for HR management, which it sells to enterprise customers on an annual subscription basis. Service HR has a few negotiations under its belt, and it turns out that the enterprise customers are uniformly requesting a performance warranty to help ensure that they receive a useful, functioning product. So Service HR asks itself, what warranties and disclaimers should I include in my enterprise agreements? Well, to answer that question, we're going to want to review what warranty terms apply at background law, and then we're going to want to review best practices to displace and disclaim those background warranties. Now, I mentioned this is the enterprise context, so we're going to start first by looking at the UCC. Under the UCC, there are several default warranties that can apply to any transaction unless they're disclaimed. There's an implied warranty of merchantability. Now, merchantability is a term of art defined under the UCC with a pretty lengthy definition which you should check out. In essence, to say that a product is merchantable means that it's fit for its ordinary purpose, it's of at least average quality, and it would pass without objection in the trade. The UCC also has an implied warranty of fitness for a particular purpose, and this goes one step further than merchantability. Under fitness, the UCC says that if a seller has reason to know that the buyer is relying on the seller's expertise to help select the product for the buyer for some particular purpose that the buyer has in mind, well then when the seller sells that good, it actually issues a warranty that it'll be fit for that purpose of the buyer. I should also mention, even though these don't go to quality of the products, the UCC also has default warranties of title and non-infringement, meaning in essence, if you sell a product, you're warranting that you have good title to it and that it won't infringe third-party rights. So that covers the implied warranties under the UCC. Of course, under the UCC, you can also create express warranties. And express warranties aren't just those that you include in your contract. In fact, under the UCC, you can create express warranties through affirmation, through descriptions, and even product samples. So what's our takeaway here as a vendor? Well, the bottom line is you can give warranties without even realizing it or knowing what they are. And from our perspective, in the technology context, many of these UCC warranties are actually inappropriate for software and SaaS. The reason I say that is if you're selling a software product, that's a sophisticated piece of technology with a specific feature set, and it likely can be used and configured in many different ways. So a general statement that your product is of average quality, much less fit for a buyer's particular purpose, simply may not map to your product. After all, your product may not be easy to compare to competitors' products. You may have a different price point, and so on and so forth. So you, as a vendor, you really don't want to expose yourself to these default warranties. Well, what's a better approach? We recommend that vendors offer an express limited warranty that's scoped to your product. Here's what Service HR came up with. Service HR warrants that the service will conform substantially to the documentation. 2 points I want to highlight here. One, we tied it to Service HR's documentation. Again, Service HR offers a sophisticated technical product that it developed, and its documentation is really the best and definitive description of how that product will operate. You'll also notice that we highlighted substantial conformance to that documentation. And the idea here is that the warranty shouldn't cover immaterial deviations. For instance, if the documentation says that a menu should be green and in real life it's blue, that's not a warranty claim. That doesn't go to the heart of the product. Likewise, if there's a minor bug with how Service HR operates, that's best addressed through support. It's not a warranty claim either. Okay, so we know that we want to adjust the scope of our warranties, but what about the remedies if we breach? Well, looking back to the UCC, there are actually a number of remedies that a customer can seek, and which remedy it picks is up to it. First, the customer can simply reject the goods as non-conforming. It can also seek to recover the difference in the value between what it received and what it paid for. Particularly scary for vendors, a customer can seek cost of cover, and this means that the customer could actually go and buy your competitor's product and then foot you with the bill for the difference between the prices. Finally, the customer can seek incidental and consequential damages. Well, all of these are problematic and somewhat scary for software and SaaS vendors because they're open-ended remedies that you don't control, that you probably didn't factor into your pricing. So what's a better approach for vendors? Well, as a vendor, we're going to want to offer a more well-defined, close-ended remedy. So we'll start with a basic obligation to fix or replace the product if it doesn't work. Failing that, we would terminate or allow the customer to terminate the agreement and provide a refund. Now, the exact amount of the refund will depend on what type of product you offer. On a perpetual software license, usually the refund will be the full license fee. For a SaaS subscription, you're usually going to provide a prorated amount reflecting the unused portion for the period after termination. And the refund amount is closely tied up with warranty period issues, which we'll discuss shortly. Before we move on, though, I do want to emphasize that, again, these remedies should be well-defined and close-ended rather than the open-ended remedies under the UCC. And you need to make sure that these remedies are the customer's exclusive remedies for performance issues in lieu of those other default UCC remedies that we discussed. Okay, so the final piece of structuring your warranty will be warranty period and timing concerns. Here's what the background law has to say. Well, under the UCC, it turns out there actually is no defined warranty period. there is a general 4-year statute of limitations for breach under the UCC. Now, that doesn't necessarily mean that your warranty period itself is 4 years, but it could potentially permit a warranty claim 4 years after the fact. As I mentioned, we'll talk more about consumer issues later. For now, I just want to flag that in California, if you sell a new consumer product and don't specify a warranty period, you'd actually have a default warranty of 1 year for the implied warranties of merchantability and fitness for a particular purpose. Well, as a vendor, if that all sounds sort of open-ended, you're right. And we're going to want to take a much more defined approach to our warranty period. On a perpetual software license for a vendor, you're going to want to set a warranty period of 30 to 90 days after initial delivery of your software. And I said initial delivery because we really don't want that warranty period to restart every time you issue a maintenance release. After all, that could produce a perpetual warranty. Finally, to have a fair chance at validating that there's an issue and then fixing it, you're going to want customers to give you notice of their warranty claim. And in perpetual software licenses, typically you're going to require that they give you notice within that defined 30 to 90-day period. A SaaS subscription is a little bit different. In SaaS, usually the warranty period is actually rolling throughout the subscription term. And the idea here is that unlike installed software that sits on the customer server, with SaaS, the vendor is actually responsible for operating and maintaining the service throughout the subscription term. So rolling warranty is customary here. Nonetheless, you still are going to want to make sure that you're requiring customers notify you of any warranty period within a fixed period after discovery, and usually that's 30 days in SaaS. All right, well, to sum up, because warranty involves termination and refunds, you're going to want to build in a structure that gives you certainty over when warranty will kick in. Second, because warranty timing will affect your revenue goals and your revenue recognition, always work with your finance team as you're building your warranty structure. All right, so that's the nuts and bolts of structuring your warranty itself. But to make sure that you have a proper warranty, you need to focus on disclaimers as well. And in fact, disclaimers are just as important as structuring the warranty provision. Let's review the background law once again. Under the UCC, it turns out that you can disclaim implied warranties. You just need to do so properly. And in fact, there's some magic language to do that. For the implied warranties of merchantability and fitness for a particular purpose, you can knock those out by using the terminology as is. Now, you can reference them by specific name as well, but using as is, you'll be sure to knock those out. For the statutory warranties of title and non-infringement, it's a little bit different. And under the UCC, you actually need to call those out specifically by name. You can't say as is to knock those out. Now, that's just a quirk of how the UCC is written and something you should know about when you write your disclaimers. Finally, express warranties, like those you may have inadvertently created through affirmation or product samples, need to be expressly disclaimed. So that's why in your warranty disclaimers, you'll see that there's disclaimers not just of implied, but also express warranties. And of course, as we all know, your disclaimers must be conspicuous. Most often you'll see them in all caps, but you could also put them in bold or a different color as well. Now, when we talk about warranty disclaimers, there's another important concept to consider including, and that's called failure of essential purpose. We discussed earlier making sure that your warranty is the exclusive remedy for performance issues. And it turns out that under the UCC, you can agree on a limited or exclusive remedy if there's a breach. But if that remedy fails of its essential purpose, then all of those default remedies we described before may be available. And I'm talking about things like cost of cover and incidental damages. All right, so let's unpack that. What does a failure of essential purpose mean? And we'll take the example of Service HR. Suppose that Service HR wrote its warranty as follows. Customer's exclusive remedy for breach by Service HR of the foregoing performance warranty is for Service HR to use reasonable efforts to correct the nonconformance. Well, you notice something there. This doesn't include that termination and refund remedy that we discussed before if Service HR can't fix the issue. So that raises the question, what if they don't solve the problem for the customer? Well, in this case, Service HR may have technically fulfilled its warranty obligations by trying to fix the problem, but if it didn't fix the problem, then the customer is left with a broken product that it can't really use. And under the contract, no recourse. So a court might well look at that and say, wait a minute, Service HR, the exclusive remedy that you identified failed of its essential purpose, which is to make the customer whole, and therefore we're going to say that all of those other UCC default remedies are back on the table. Okay, well, to sum up, for customers, failure of essential purpose makes sense. It's a protection against lousy exclusive remedies that you may receive from vendors. But for vendors, it's actually a really problematic result because, once again, it exposes you to all those open-ended UCC remedies that we were trying to avoid in the first place. So for a vendor, what's a better approach? Well, first, as a vendor, make sure that your exclusive remedy is meaningful. Go ahead and include that termination and refund if you can't fix the problem. That makes the customer whole. Second, there's some language that you'll want to add to your contract, and that says that limited remedies will apply regardless of any failure of essential purpose. You'll often see this in the limitations of liability, and the idea here is that the parties are agreeing that the limited remedies are reasonable and should apply no matter what else happens under the contract. Okay, that covers the warranties and it covers the disclaimers, so let's sum it up and put it all together. Your warranty, as vendor, should be an express limited warranty tied to your standard technical documentation. You're going to want a defined warranty and complaint reporting period. You're going to want to make sure that the remedy that you offer is a meaningful one, and that goes back to that failure of essential purpose that we just discussed. And then finally, of course, you want to state that your warranty is the exclusive remedy for performance issues. When it comes to disclaimers, make sure to use that magic language. Use as is, that disclaims merchantability and fitness for a particular purpose, and call out title and non-infringement by name. Also include the statement that remedies will apply regardless of any failure of essential purpose. And if you want to see how this looks in action, you can look at the example warranties and disclaimers that we provided in the tools. So that covers our basic warranties and disclaimers in the enterprise context. But what about for consumer products? And here it turns out that Service HR is actually planning to launch a consumer product. It's going to be a direct-to-consumer job search tool. And it wants to know what rules apply to consumer warranties and what should Service HR consider including in its consumer-facing terms. Well, let's check out the background law again. We have the Magnuson-Moss Warranty Act. This is the federal lemon law for consumer products, and it covers tangible personal property normally used for personal, family, or household purposes. Again, each state has its own laws. And in California, that's the Song-Beverly Consumer Warranty Act, which corresponds to Magnuson-Moss in many ways. And this covers new products or parts thereof that are used, bought, or leased primarily for personal, family, or household purposes, excluding clothing and consumables like food or toothpaste. All right, so if you are offering consumer goods, these are some important requirements that you're going to have to observe. I should point out that there are open questions as to whether these consumer protection laws apply to intangibles like software as opposed to tangible goods. Nonetheless, many commentators think that these consumer protection laws should protect consumers of software, and we believe that courts may be likely to resolve any ambiguity in how these laws apply in favor of protecting the consumers. So if you are selling even an intangible good to a consumer, you should think about how to deal with these laws. Finally, even if you're only selling into the enterprise and aren't offering consumer goods at all, this section may be of interest to you because it turns out that these consumer protection laws are the origins of some common disclaimers that you may have seen. All right, so what do these consumer warranty laws require? Well, under the Magnuson-Moss, first you should know that there are some labeling and notice requirements for your warranties. If you offer anything short of what amounts to a full lifetime warranty, then you need to conspicuously label that warranty as limited. Also under Magnuson-Moss, you need to make that warranty available in a single document that's clear, easy to read, and available before sale. In California, there are some additional notices if you sell a product as is with no warranty, and these are basically designed to make sure that the consumer knows that the risk of buying and using that product fully falls on them. Now, these are very lengthy laws at the federal and state level, so you should know that there are additional requirements that may apply. There are additional requirements if you sell service contracts for your good. There may be requirements for you to establish repair centers within the state of California under Song-Beverly. And also under Song-Beverly, if you sell assistive devices like a hearing aid or wheelchair, there are some specific substantive requirements that you need to meet. So what are our basic takeaways? Well, first, at minimum, label any performance warranty that you offer as a limited warranty. Second, always do a product-specific analysis to see how these laws apply to you. Another important point to understand under these consumer laws is how they affect the implied warranties. So to back up, these laws don't require you to offer any express written warranty. You can still sell your products as is. That being said, if you do offer a written warranty, the consumer protection laws will limit your ability to disclaim the implied warranties of fitness for a particular purpose, and merchantability. And the idea here is, in essence, if you're offering some warranty to consumers, the law wants to make sure that that's backed up by some basic protections, that you're not just offering a junk warranty. All right, so what do the laws require? Well, under Magnuson-Moss, if you offer an express warranty, you can limit the implied warranties to the same warranty period that applies to your express warranty. So for as long as that express warranty applies, merchantability and fitness for a particular purpose will apply as well. Song-Beverly supplements that in California. It says that for new products, that minimum period for the implied warranties must be at least 60 days. And if you didn't specify a period for your basic warranty, the default would be 1 year for those implied warranties. All right, well, as a vendor, what can you do? How should we address this in our terms? Well, you can't change the law, but you can try to limit those implied warranties to the minimum period allowed by law. And you can do that by adding something like the following to your warranty disclaimers. You may have other statutory rights. However, to the fullest extent permitted by law, the duration of any statutorily required warranties shall be limited to the shortest period permitted by law. And like I mentioned, for enterprise deals, you may have seen this in your contracts. It probably doesn't hurt anything to include an enterprise deal, but the source of this is really the consumer protection laws. All right, well, that covers the basic nuts and bolts for warranties and disclaimers in both the enterprise and consumer context. And now we're going to shift gears to talk about something we like to call choose your own disclaimer. All right, so we've written our warranty provisions. It's locked down. We've got our exclusive remedy. We've got great disclaimers. So what else could go wrong? Well, as a vendor, we invite you to think through a few questions. First, what performance issue are you most concerned about? Or given the nature of your product, what type of dispute would you most like to avoid? And then based on the answers to those questions, in addition to all those standard warranty disclaimers we just discussed, we recommend consider including a targeted disclaimer that makes the party's intent crystal clear as to these key risk factors. Let's walk through a few examples. First, we have an antivirus software vendor, and they've added a disclaimer that says, we do not guarantee that our product will identify all viruses or malware. Now, that may sound strange. Isn't the software supposed to be protecting me from malware? Well, the vendor's idea here is that viruses are constantly being created, and virus definitions are constantly being updated. So it wouldn't be possible for them to catch literally everything that's out there, and they want to make sure that the consumer knows that. Second, we have a business intelligence platform, which is used to create reports or analytics that supports companies when they make strategic decisions. They added a disclaimer that says that the customer assumes all responsibility for determining whether the output of the service is accurate or sufficient for its own business purposes. And the idea here is, as the vendor, it's telling its customers, great, use our product to support your decisions, but we're not responsible for the decisions that you make. And finally, we've got our old friends, Service HR. They added a warranty for its enterprise customers that says, we expressly disclaim any warranty that your use of the service will ensure your compliance with employment laws or any other legal or regulatory obligations. And the idea here is that certainly Service HR, it feeds into HR, and so it runs up against various employment law and other compliance functions, but it's up to the customer how it uses the service, and Service HR isn't ultimately responsible for the customer's own compliance with laws. Now, a few things to think about if you do add your own disclaimer to your contract. On the vendor side, you should think about how your customers will read your disclaimer and try to avoid overreach. You should situate your disclaimer in a reasonable balance of responsibilities. So for Service HR, we didn't say that Service HR has no compliance with law obligations. We just said that it wasn't responsible for the customer's own compliance with laws. And of course, if you are a customer, you should make sure to read those lengthy warranty disclaimers that you see in your vendor agreements. You never know what you might find or what you might want to change. Now let's shift gears and talk about how warranty relates to some other contractual provisions, namely service level agreements and support. Now these are related provisions with some overlap, but they're also different, and it's important as a vendor to understand the distinctions. So let's take a look. Well, warranty, we've got this one down. We know what it covers. It covers the fundamental performance of your product. The remedy for breach, as we've just been discussing, will be to fix, terminate, or refund, and that's identified as an exclusive remedy. Service level agreements cover something a bit different, and usually it's going to be the uptime of a SaaS product, meaning it's available, let's say, 99.9% of the time in a given month. The standard remedy for a breach of the SLA will be service level credits and sometimes a termination and refund for severe or chronic downtime. As with warranty, it's identified as an exclusive remedy. What about support and maintenance? Well, this is geared toward the resolution of technical issues and also the provision by the vendor of bug fixes, updates, and upgrades. What's the remedy for breach? Well, it's a standard contractual obligation. There usually is no defined remedy. Okay, well, as a vendor, you should know these are related protections, but they have different purposes and remedies associated. And all three can address customer concerns about product performance. They can also be sources of confusion for your customers. So if you have the distinctions down pat, you'll be able to address those confusions. Now, if you're watching closely, you'll notice something curious, which is that we have two remedies which could relate to the same underlying problem and which are both identified as exclusive remedies, and that's warranty and SLA. So how does that come up in a customer agreement, and as a vendor, how should you think about that? Well, as a vendor, how do we resolve this concern, and how can we thread the needle between the SLA and warranty remedies? Let's check out an example from Service HR. Service HR, like a lot of vendors, offers a standard performance warranty and a standard SLA, each with an exclusive remedy. And in the course of a negotiation, its customer raises its hand and objects. It says, hey, wait a minute. If that solution isn't working, that could be both a warranty claim going to performance, and it could be an SLA issue going to uptime. So how can both of those remedies be exclusive? And Service HR thinks about this a little bit and says, well, that's a fair point, but what I really want to avoid is the customer receiving both an SLA credit and a warranty refund for the same problem. After all, that would be double dipping financially. So how does Service HR deal with this? Well, let's check out what they added to their agreement. First, you'll see the standard SLA language, which is that service credits are the exclusive remedy for service downtime. Next, Service HR adds a new clause, and it says the following: notwithstanding the foregoing, if a failure by Service HR resulted in both a service level shortfall and a breach of the performance warranty, then the customer may seek remedies under either the SLA or the performance warranty, just not under both for the same failure. So if an issue is both an uptime problem and a performance problem, it's up to the customer which remedy to pursue. They just can't pursue both. All right, so we've covered quite a lot from the vendor perspective, but what about when you run across customer objections to your warranty structure itself? We've put together a few tips and tricks here to help you deal with common customer concerns. First, let's take a customer request that your warranty be that your product strictly conforms with its documentation rather than substantially conforms with your documentation. And we discussed this one a bit earlier. Your response here should be pretty simple. Warranty, after all, is a significant remedy for problems that go to the heart of product performance. It's really not designed for immaterial issues or minor bugs. So strict conformance isn't appropriate. Substantial conformance is the appropriate standard. Here's another one you might get from a customer. The customer wants the warranty to be tied to its own particular specifications geared to its business needs rather than your documentation. And here, remember that you're offering a sophisticated technical product. Your response here should be something like, well, as vendor, we offer a standardized platform to all of our customers, and our documentation is the best description of how it operates. It wouldn't be possible or appropriate to try to describe our product with reference to some external specifications that the customer has. Finally, and here's a tricky one, the customer says, yeah, your warranty is fine. I don't want the warranty remedies to be exclusive remedies for breach. Now, as a vendor, how should you think about this? In our view, this gets to something that's really at the heart of this warranty provision, and that's that your express performance warranty is a trade-off. The customer receives something important here. It receives contractual certainty about its remedy and the process if there is a warranty issue, and that's all without having to go to court. In fact, it's a business-friendly remedy that's built right into the contract itself. Now, as a vendor, you would only be able to offer this remedy if the customer is also giving up other remedies that may apply at law. You couldn't offer this affirmative contractual remedy that's an automatic gift to the customer if the customer could also turn around and sue you for breach damages in addition to its warranty refund. All right, what if your customer still isn't satisfied with your warranty or has serious performance concerns about your products? Well, there may be some other ways to address those customer concerns and take some pressure off the warranty. First, say you offer evaluation licenses that allow the customer to try your product before they buy it. That should get them comfortable both with the product operation itself and with the warranty structure that you've offered. Second, we've talked about SLA and support. While these are somewhat distinct from warranty, they can also be great ways to get the customer comfortable with your overall package. And then finally, you should highlight good facts, and this is totally separate from the contract. If you've never had a warranty claim, that's something that can be great for a customer to know to get them comfortable. Or if you've received industry awards or accolades for your support organization, you should highlight that as well. All right, well, that about wraps it up. We've covered the background law for warranties, as well as best practices for drafting and negotiating warranties in your customer agreements. As a next step, we invite you to join one of our roundtables where we can discuss any questions you have about warranties or any challenges you faced in your own practice. We hope to see you then.